If you own a store, a restaurant, a salon, or any business open to the public in Hawaii, the sign on your front door just changed meaning overnight, and most business owners there do not know it yet. On June 25, 2026, the Supreme Court handed down a 6-3 ruling that flipped the legal default for concealed carry on private property open to the public. Before that date, the law assumed guns were not welcome unless the owner said otherwise. After that date, the law assumes the opposite: carry is allowed unless the owner posts a sign or says otherwise. If you visit Hawaii, work there, or live there and carry a firearm, this affects you just as directly because the rules for where you can legally carry into a business just reversed in a single ruling. Stay with me because getting this wrong in either direction, as a business owner or a permit holder, can mean real legal exposure. Before we get into exactly what changed, if you run a business open to the public anywhere, not just in Hawaii, hit subscribe right now, because this is the kind of ruling that reshapes local ordinances in other states within months, not years. Drop a comment telling me whether you think the burden should fall on the property owner to opt out or on the state to protect public spaces by default. I want to see where you land on this. Let's start with some context, because this ruling did not come out of nowhere, and understanding where it fits in the bigger picture tells you why it landed the way it did. Back in 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruin, a landmark case that recognized an individual right to carry a handgun in public for self-defense, and established a new legal test, now called the historical tradition test. Under that test, a modern firearm regulation only survives a constitutional challenge if it is consistent with how the nation actually regulated firearms at the time the Second Amendment and later the 14th Amendment were adopted, not whether a state legislature today thinks the regulation sounds reasonable. In the years after Bruin, several states responded by rewriting parts of their concealed carry laws, and Hawaii was among the most aggressive. Hawaii's legislature passed a law establishing that on any private property open to the public, a grocery store, a coffee shop, a shopping center, a restaurant, concealed carry was presumed illegal unless the property owner had affirmatively and explicitly given permission. In practical terms, that meant the default protection ran entirely against the permit holder. Silence from a business owner, which describes the overwhelming majority of businesses that never think about firearms policy one way or another, functioned as a legal prohibition. This is the exact framework that ended up in front of the Supreme Court, and it is worth understanding just how sweeping that default actually was before we get into how the court dismantled it. Let's start with the case itself. The ruling is called Wolford versus Lopez, decided on June 25, 2026, by a vote of 6-3, with Justice Samuel Alito writing the majority opinion. The case came out of Hawaii, a state that had passed one of the most restrictive default rules for concealed carry in the country. Under that law, if you had a valid concealed carry permit and walked into a grocery store, a coffee shop, or a hardware store, you were presumed to be breaking the law the moment you crossed the threshold, unless the owner had specifically and explicitly given you permission to carry there. No sign, no permission meant no carry, even if the owner had never thought about the issue at all. Justice Alito's opinion for the majority did not treat that framework gently. He wrote that Hawaii's law was, in his words, presumptively unconstitutional, and he went further, stating that the law unquestionably imposed a new and significant burden on the exercise of the right to bear arms. Think about what that sentence is actually doing. The court is not saying Hawaii's goal was illegitimate. It is saying the mechanism Hawaii chose, silence equals prohibition, placed the entire weight of a constitutional right on whether a business owner remembered to say yes. The majority opinion walked through the practical reality of that framework in detail, noting that under the common law rule that existed for most of American history, property owners who wanted to exclude firearms could do so easily by posting a sign or communicating their preference directly, and that this default, permission unless stated otherwise, was the historically consistent approach. Hawaii's law inverted that long-standing default entirely, and the majority found nothing in the historical record to justify that inversion. The opinion also addressed a practical concern raised during argument that some business owners might be reluctant to post a sign explicitly welcoming armed customers for fear of alienating other patrons, even if they had no objection to permit holders entering quietly. The majority found that this reluctance was precisely the kind of chilling effect the Second Amendment's plain text was meant to guard against, where the choice between two default rules ends up functionally determining whether the right can be exercised at all. The majority ruled that the correct default has to run the other way. Carry is presumptively allowed on private property that is open to the public, and it is the owner's responsibility to post a sign or communicate directly if they want to exclude firearms. 3 justices dissented from that outcome, which means this was not unanimous, but a 6-justice majority is still a decisive result, and it is now the binding rule. Now let's translate that into what actually happens on the ground for a business owner in Hawaii, because this is where most of the confusion is going to come from in the weeks ahead. Before June 25th, you as a shop owner did not need to do anything to keep guns out. Silence was your protection, full stop. After June 25th, silence does the opposite, and if you want your business to remain a no-carry zone, you now have to take an affirmative step, a posted sign at the entrance, or direct verbal notice to a specific person carrying. If you do nothing, the legal presumption is that permit holders are allowed on your premises. Picture a small bakery in Honolulu whose owner never thought about gun policy at all. On June 24th, that bakery was gun-free by default. On June 26th, without the owner changing anything, it became a location where lawful carry is allowed, simply because nothing was posted. Now picture a second business. A family-owned restaurant whose owner does have strong feelings about firearms on the premises and wants to keep it that way. Under the old law, that owner never had to think about signage, because the state law did the work automatically. Under the new law, if that same owner does not get a compliant sign posted, their actual preference is legally irrelevant, because the presumption now runs against them by default. Your action step is direct. Decide today whether you want firearms excluded, and if you do, get a compliant sign up immediately because the default no longer protects you, and check your local jurisdiction for specific requirements about sign wording, size, and placement, since some counties in Hawaii may issue guidance on what counts as adequate notice under the new default. For permit holders, the shift works in the opposite direction, and it removes a trap that used to catch even careful, law-abiding gun owners. Under the old rule, a permit holder walking into an unfamiliar business had no reliable way to know whether they were breaking the law simply by entering, because the default ran against them everywhere unless they had confirmed permission, which almost nobody ever did in practice. That created a genuinely unfair situation where a responsible, permitted carrier could be committing a technical violation constantly, in store after store, with absolutely no way of knowing it, because there was no sign to check, nothing to look for, just an invisible legal tripwire built entirely on the owner's unstated preference. Under the new rule, a permit holder can walk in and be on solid legal ground unless that business has posted a clear notice against firearms. Your action step here is just as direct. Watch for posted signage the way you already watch for it in other carry states, and if you do not see a sign, the legal presumption now runs in your favor. There is an important boundary here that you need to keep straight, because this ruling did not touch every category of restricted location, and getting this wrong could still land a permit holder in real legal trouble. Wolford versus Lopez is specifically about private property open to the public, ordinary businesses like stores, restaurants, and shopping centers. It did not address and did not strike down separate categories of locations that states can still restrict under long-recognized historical traditions, places like courthouses, legislative buildings, polling places, and certain other government facilities. Those sensitive place restrictions were not part of this case and remain fully enforceable in Hawaii and everywhere else. So while the default for an ordinary grocery store or coffee shop flipped in favor of carry, a permit holder still cannot assume that flip extends to every kind of property. Your action step here is to keep treating sensitive place categories exactly as you did before this ruling, and to understand that Wolford versus Lopez narrowly reset the default for privately owned, publicly accessible businesses, nothing broader than that. There is a broader piece of this you need to understand, because it explains why this ruling matters even if you never set foot in Hawaii. The legal reasoning underneath Wolford versus Lopez comes directly from the historical tradition test the Supreme Court established in the 2022 Bruin decision, which asks whether a modern firearm regulation is consistent with the nation's historical tradition of firearm regulation. Alito's opinion applied that same test to strike down Hawaii's opt-in default, and legal analysts are already watching other states that adopted similar rules after Bruin, because the same reasoning applies just as directly to theirs. A handful of states wrote laws structured almost identically to Hawaii's in the years following Bruin, treating silence on private property as prohibition rather than permission, often as part of broader legislative packages responding to the expanded carry rights Bruin recognized. Those laws are now sitting on genuinely thin legal ground, because a state defending an opt-in default in court would have to explain why its law survives when a nearly identical Hawaii law did not, and that is an extremely difficult argument to win. If your state passed a comparable requirement for private property carry after 2022, do not assume it survives, and watch for litigation testing that law in the coming months, because attorneys who represent gun rights organizations read this opinion the day it came out and are already evaluating which state laws look most vulnerable to a nearly identical challenge. Let's step back and connect these pieces. What the Supreme Court did in Wolford versus Lopez was decide who has to make the first move on a piece of private property, the gun owner or the property owner, when the law is otherwise silent. For decades, states like Hawaii built their public safety framework on the assumption that silence protects the public. The court just ruled that silence has to protect the right instead, and it is the property owner's job to speak up if they want something different. That is a real inversion, and it changes the daily calculation for every business open to the public and every concealed carry permit holder in that state, starting immediately, not after some future compliance deadline. If this cleared up what actually happened in Hawaii, and what it means for you whether you carry, own a business, or both, hit that like button so more people get an accurate breakdown instead of the vague panic headlines circulating right now. Subscribe, because rulings like this one are going to keep landing as more states get tested under the same framework, and I will be tracking every one of them. Drop a comment telling me whether your state has a similar law on the books.